All right, hello everybody. I'm Will Martin. I am North Carolina Realtors legal counsel, and I am here to talk about some recent forms changes to the NC Realtors residential forms, covering the most significant changes today. In the next 20 minutes or so, just going to cover changes to two different forms. Happen to be two of the most widely used forms that we have, the offer to purchase and contract, Form 2T, and the exclusive right to sell listing agreement, Form 101. There are actually 31 residential forms that underwent some kind of change in the last year, so you can see that just as COVID pandemic didn't stop the real estate market, it didn't stop the forms committee either. Most of those changes are very technical in nature. For example, you're familiar with the notice to buyer and notice to seller forms that can be used to unilaterally terminate a contract. They're forms 350-T, 351, 352, and 353-T, depending on whether it's improved property or vacant land. We decided to change the names of those forms because we think they're important forms, and it seemed as though people might have some difficulty finding them when they look by word. They might be looking for the word termination, but the first word in the names of all those forms was notice. And so we've just changed the names of the forms. So the first word will be termination. Hopefully that will make it easier for members who are trying to terminate a contract to find those forms. So that's an example of the technical nature of most of the changes we've made to the forms, but there are some very substantive changes, especially to the offer to purchase and contract, that I want to go over with you today, at least the most important of those changes. I did a detailed bullet point summary of all the changes that you can find on the NC Realtors website. If you log in, sign in with your username and your password, and then you click on the Q&A quick link at the top of the next page, then you would click on the forms button and expand that, and then click on summary of forms changes, and you'll see a link to the document I created. And embedded in that document are links to the actual forms themselves, marked up versions of them, so you can see exactly what changed in each of those 31 forms if you would like to. I'm told that it will have a few minutes for me to answer questions at the end, and so if you want to go ahead and submit questions as they come up, I will try to address them at the end of the presentation. If I'm unable to get to some of them, please feel free to call us on the legal hotline or email us on the legal hotline. My partners John Waite and Bill Gifford and I take calls every day that NC Realtors is open, and the email address is legalhotline@ncrealtors.org, legalhotline@ncrealtors.org. You can also call the NC Realtors main line, 336-294-1415, and the call will be transferred to us. We're actually in Winston-Salem. We'll be happy to take your call and answer any question about the changes to these forms. The offer to purchase and contract, I'm going to address changes to 5 different areas of the contract. The delay in settlement provision has a very significant change. Special assessments section has changed somewhat. We've done some additional things regarding the due diligence fee that I want to cover. We've restructured the section in the buyer representations where the buyer represents how they intend to fund the transaction. And we've also created a new remedies section, paragraph 23, toward the end of the contract. I'm going to hit on all 5 of those areas here in the next few minutes. The delay in settlement provision, we created that provision way back in 2008 3 years before the due diligence contract even rolled out. And it has brought a lot of clarity to the question of how long does a party have to wait if the other party is unable or unwilling to complete the transaction. As you know, well, it actually started out with a 30-day delay period initially. That was reduced to 14 days, and now it's been reduced a little further, as I'm going to say here in just a minute or two. This provision was really designed to address situations where something unexpected would come up after the parties entered into their contract that caused a party to be unable to complete settlement by the agreed upon date. This provision does not, I repeat, does not give a party an automatic right to a delay in settlement. It was not designed to be used for matters of convenience. It was not designed to give a buyer the ability to put an unrealistic settlement date in an offer, to make their offer look better, with the idea of pushing the actual settlement date out by up to 14 days. It was also not designed to give a green light to a bank that wants to delay the processing of a loan because they know that in our contract there's up to a 2-week delay in settlement. So in order to minimize the impact that a delay in settlement will have on a non-delaying party and to discourage excessive delays, the permitted delay in paragraph 12 has been reduced from 14 days to 7 days. So we've cut it in half. In addition, in order to emphasize the fact that the delay in settlement provision is only intended to apply when absolutely necessary, the wording has been changed from the delaying party being quote-unquote unable to complete settlement by the settlement date to it is not possible for the delaying party to complete settlement on the settlement date. So I think we've strengthened the language just a little bit there to try to make it as clear as we possibly can that this provision is only supposed to be applicable if there really is a true need to delay the settlement. Okay, what have we done with the due diligence fee? The old version of the contract did not specify the form of payment of the due diligence fee, and we're beginning to see occasional disputes where the buyer may want to pay the due diligence fee in a particular form and the seller doesn't want to. So we decided we ought to go ahead and give the parties the ability to agree up front, just as they do and have been able to do with the initial earnest money deposit for a long time, on the form of payment of the due diligence fee. So in the new version, the parties will need to agree on the form of payment. That's cash, personal check, official bank check, wire transfer, or electronic transfer. If the parties agree that the due diligence fee will be paid by electronically, the seller agrees to cooperate to the extent necessary to enable the buyer to complete the payment. And on the other hand, the buyer will agree to bear any costs that may be associated with making that payment electronically. What else have we done with the due diligence fee? In paragraph 1D of the new version, it specifically states that the buyer's failure to deliver the due diligence fee timely and the seller terminates, the seller will be entitled to recover not only the due diligence fee, but any earnest money that was paid or payable, and possibly attorney's fees. Wording has also been added at the beginning of paragraph 4G, which is in the due diligence section, where it gives the buyer the right to terminate for any reason or no reason prior to the end of the due diligence period. There's now a clause that makes it clear that the buyer's right to terminate during the due diligence period is predicated on the buyer actually having paid any agreed upon due diligence fee. Why have we made these changes? We've gotten quite a few reports about buyers entering into contracts calling for the payment of a due diligence fee and then changing their minds and refusing to pay it. So we want to try to discourage buyers from not paying a due diligence fee that they've agreed to pay, and so we hope that these changes will help in that regard. Special assessments. The seller's representations regarding the existence of confirmed and pending special assessments has been removed from the contract. The seller is still responsible for paying any assessments that are approved prior to settlement, whether they're payable in full then or possibly in the future. As long as the amount is known or can be reasonably estimated, the seller is still responsible for paying those approved assessments. That has not changed. And the buyer continues to be responsible for paying assessments that may be approved after settlement. That too has not changed. And we've added a new subparagraph on in the due diligence section of the contract where we list the items that the buyer should consider investigating during the due diligence period. We've added a new subparagraph regarding special assessments to encourage the buyer to independently verify the existence of special assessments that may be under consideration or that have been approved. Why have we made these changes? Well, for one thing, the seller's representations regarding the existence of confirmed and proposed special assessments, especially proposed special assessments, is of somewhat questionable value to begin with, because the seller very oftentimes is unaware of the existence of those assessments. We also saw lots of cases, have for many years, where the blanks where the seller can list any confirmed or proposed special assessments have been used for a purpose that they weren't intended for. Rather than the identification of the special assessments, it's being used to try to allocate responsibility for the payment of special assessments. Typically would say something like none known, if any, seller to pay. Well, that just doesn't work very well when you're talking about proposed special assessments. And so we were trying to address that problem by just eliminating the blank altogether. And as I said, we hope that this will also encourage buyers to independently verify the existence of special assessments that have been approved or that are under consideration. It doesn't come up often, but it can be a pretty big deal. And the buyer should perhaps not be relying so much on the seller's representations about the existence of those assessments. A note to listing agents: just because we've added special assessments to the laundry list of due diligence items the buyer's recommended to investigate, if you know, or under the circumstances you should know, about the existence of a special assessment under consideration or approved, it's very likely a material fact that you would need to disclose. So just because we've tried to emphasize the buyer's due diligence investigation doesn't mean that you're off the hook on disclosing material facts. Okay, let's move on to the buyer representation regarding the manner in which they intend to fund the transaction. These changes are not so much substantive. I think it's mainly a reformatting of the section to try to make it a little easier to use. The buyer will choose cash or quote loan/other funds initially, and if the loan/other funds checkbox is selected, the buyer will indicate all sources of funding: first mortgage loan, second mortgage loan, and other sources like perhaps a loan or a gift from a family member. The down payment assistance program checkbox has been eliminated, as well as checkboxes for fixed/adjustable rate, term of loan, and interest rate. We're trying to focus on the things that are really considered to be essential. What should the seller know about the manner in which the buyer is going to fund the transaction? That's what we're trying to focus on. There's been a new sentence added at the end of the note, which is at the end of paragraph 5A, that we've gotten a fair number of questions about. already. It states that if the buyer makes a material change in the way the buyer will fund the purchase, and that change may affect the contract, that change must be disclosed as a material fact. A simple example of that would be if the buyer decides to switch loan products after they've entered into the contract, and the switching might cause the buyer to be unable to complete settlement by the settlement date. I think that would be considered a material fact that the buyer agent would be expected to disclose to the seller or the listing agent. I want to say this isn't a new duty that's being put on buyer agents. Material facts include facts affecting the ability of your client to complete the transaction. So any fact that may affect the buyer's ability to complete the transaction within the time frames established in the contract would, in my view, be considered a material fact. I want to also stress, though, that on the other hand, the addition of this sentence does not mean that the buyer can't change the way they intend to fund the transaction after the contract has been entered into, or that the seller has to consent to that change. FHA and VA financing sort of are a special case. The seller, in our view, isn't required to agree to amend the contract to add the FHA VA financing addendum to the contract, but if it doesn't involve a change in the contract, we've long been of the view that the buyer can make that change without the seller's consent. But again, we do feel as though there are situations where the buyer needs to keep the seller abreast of any changes that might affect the way the contract works. Last section of the offer to purchase I want to cover is the creation of this new remedies section, paragraph 23. In the old version of the contract, the rights that a party has if the other parties in breach were located in some different sections of the contract. So we've tried to consolidate those provisions in the same place in this new remedies section. So the wording pertaining to, well, what happens if the buyer's in breach of contract, or what happens if the seller's in breach of contract, really haven't changed fundamentally. They've just been pulled from some other places in the contract and put in this new paragraph 23. We had a couple of different attorney's fee provisions. We've kind of pulled them, and we have revised the wording of the attorney fee provision to some extent. You'll see several references in that attorney's fee part of that paragraph to a statute, North Carolina General Statute 6-21.2. Why is that in there? We don't normally like to put statutory references in forms, but we felt as though it was necessary here. The reason is that in North Carolina, there has to be a statutory basis for the award of attorney's fees, at least in litigation involving a residential real estate transaction, and the contract has to specifically provide for the payment of attorney's fees. So that's why you see the reference there. Now, whether or not that statute permits recovery of attorney's fees by one party or the other in a specific situation can actually be somewhat tricky to figure out. And so the attorney's fee provision in paragraph 23 simply provides that attorney's fees will be recoverable to the extent permitted up by the statute, leaving it up ultimately to a judge to determine a party's entitlement to attorney's fees in a particular situation. What we hope is that just the potential for an award of attorney's fees will encourage the parties to work out their differences rather than taking the matter to court. So that's all the comments I have about the offer to purchase. Let's move to the exclusive right to sell listing agreement for just a few moments. Wanted to highlight changes in 4 paragraphs, paragraphs 9, 10, 11, and 12. Paragraph 9, we've added a new warning at the end of paragraph 9, warning sellers and listing agents about potential fair housing problems associated with the seller's consideration of what a lot of people refer to as buyer love letters, and advising the seller and the listing agent to discuss how any such letters will be handled. We haven't tried to establish how they will be handled. We think that is best left up to an individual agent or a firm to decide. as a matter of firm policy. How are we going to handle this situation? But hopefully the warning will encourage discussion about it up front. We've added something pretty similar in the buyer agency agreement as well. Paragraph 10, the marketing paragraph, has been reorganized in an effort to make it hopefully easier to understand and use. I don't consider any of these changes to be really substantive in nature, but in the old version of paragraph 10, the default was that the marketing would begin on the effective date, which is the date the parties have both signed it, unless they were going to agree to what we called a delayed marketing date. And so if there was going to be a delayed marketing date, you had to fill in the blank about when that date was going to be, a date after the effective date. So we've kind of reformatted it now so that in the new version, we've eliminated that delayed marketing date blank, and instead the parties will establish in all cases when marketing will begin. So you're going to need to fill in that blank in all cases, and it could be on the effective date or it could be at a date later. Once you've done that, then the seller and the listing firm are going to be required to select either public marketing or office exclusive. It's one or the other. If public marketing is selected, then you check the applicable marketing options. Those haven't really changed. You're familiar with those. If coming soon marketing is selected, there is another date blank you need to fill in, and that's the date that the status of the listing will be changed from coming soon to active. We have added a new sentence in the office exclusive subparagraph, if that's selected, to make it clearer that public marketing is prohibited if the office exclusive option is selected, and that if public marketing will take place at a later date, it will be necessary to amend the listing agreement. So you'd start out, check the exclusive office exclusive option. If you decide later on that's not working out, you want to change to public marketing, the seller would check the public marketing blank, you would initial and date the changes, and you would select the options that you were going to use in the public marketing campaign. Paragraph 11, in the old version of Form 101, there was an assumption that the listing firm would act as the escrow agent. Of course, given the increasing number of firms that don't even maintain trust accounts and the increasing use of closing attorneys holding earnest money deposits, paragraph 11's been changed to reflect current reality. In the new version, the listing agent will need to check the appropriate box to indicate whether the agent's firm maintains a trust account, and the wording has been changed to clarify that the escrow agent will be identified in the sales contract. Paragraph 12, mainly formatting changes. There are 14 representations that the seller's making in paragraph 12, and we've kind of changed the order of those representations. We're grouping together the 8 representations that the seller is making to the best of seller's knowledge. There are 8 of those, and then there are 6 representations that are not limited by best knowledge standard, and so we've kind of grouped those together. Now we have added some new wording in what will be subparagraph N that will require the seller to indicate whether any fuel tanks are in use, and if not, whether the tank has been closed and the manner used to close the tank. And some of the wording in the Owners Association subparagraph has been eliminated as unnecessary or moved to the seller's duties paragraph. That's really all the time that I have devoted to formal remarks today. I'm going to see if I can smart enough here to look at these comments and answer any questions that may have come in. Let's see here. I like this one. Will, you are the bomb. That's good. Okay, somebody commented that removing the down payment assistance checkbox was not a good idea. You know, that was that was really the whole reason why we decided to look at that paragraph 5A. Was there was concern about whether or not that might have some unintended discriminatory impact. And although we have removed it as a checkbox, I think, for example, I know that some of those programs are set up as second mortgages. We would still expect the buyer to disclose the fact that they're getting a second mortgage and give a little bit of information about that second mortgage. So we're not eliminating the requirement that somebody disclose the fact that the buyer intends to use a down payment assistance program. We've just decided to eliminate the specific reference, the specific checkbox to down payment assistance programs. Let's see. Like there are a lot of comments here. Is a coming soon addendum still required with the new form? That's an MLS question. Your MLS may have a form that it requires you to use. We try to stay out of the way at the state level of the MLS rules. And so if your MLS requires the use of a coming soon addendum, you probably still need to use it. Your MLS may be changing some of its forms in light of the changes we've made to paragraph 10, but that's something you need to check out with your MLSs. Could the seller terminate if the funding goes from cash to an appraisal required loan? That's a fairly common question that we get. My short answer would be no. As long as the buyer was acting in good faith when they completed the representation saying, I intend to pay cash. Sometimes, a buyer may do that to try to make their offer look better. And if you can prove that, that's not good. I think that would be considered a breach of contract if you're not answering that question in good faith. But if after you indicate that you're going to pay cash and maybe you demonstrate to the seller that you can pay cash, your financial advisor might say, you know what, you may want to consider getting a loan to try to take advantage of the mortgage interest deduction. And we think that's okay. And you don't need the seller's consent to do that. Let's see, why don't we address due diligence in the listing agreement? No, it's not a bad idea. I'll say this, if you've got a suggestion for a change to one of our forms or possibly the creation of a new form, let me know about it. Hotline's a great place to do that, and I'm kind of a pipeline to the various committees that consider these changes, and I would be happy to, if you'll send me an email to the hotline, I'll forward that to the Forms Committee chair with a recommendation that we discuss that in the fall when the committee reconvenes. A couple of thank yous. I appreciate that. Thank you all for your patience in with the technical delays that we had. It got us started a little bit late. Let's see. Regarding item 10A, this is the listing agreement. If the seller does not want to commit to a marketing date at the time of their signature, can we put contract effective date on that line? That's a good question. I would say yes. Because that's, you don't want to put something in one of these blanks that creates some vagueness or ambiguity. But since the effective date is a defined term, I think right up at the beginning it says it's when the parties have both signed the agreement, then reference to the effective date, capital effective date, I think would be okay. I'm being told that I need to sign off now. If I've got other questions I didn't answer, I'll try to answer those somehow, or if you have other questions, like I said before, don't hesitate to call or email the legal hotline, legal hotline at ncrealtors.org, or you can call at 336-294-1415. Thank you all for your time today. I hope this has been helpful, and everybody take care. Have a good day.